And thanks to everybody for joining us today. So my name is Anniss, and I'm going to be speaking today along with my colleague Kirsty Hunt. For those of you who don't know much about Quay HR, we are a subsidiary of VWV. We're an HR consultancy, and we work with a whole range of clients, including law firms. Kirsty and I are both employment lawyers by background, but other members of our team are really experienced HR professionals. But Kirsty and I don't practice anymore. We work purely as HR professionals now. Could you move me on to the next slide, please, Harriet? So what we're going to cover for you today are some of the areas that we thought would be perhaps most relevant or most topical at the moment for those of you in terms of managing your staff within your firms. So the sorts of touch points that you might come up against with hopefully some practical tips for managing them. So we're going to look at dealing with requests for time off, managing the menopause in the workplace, a little bit about contract and policy reviews, touching on appraisals and performance management, and then very topical, a section on post-COVID working and the sorts of things that you might be thinking about at the moment with your staff. As Jo says, really happy to answer questions as we go along if things come up, or equally if you want to ask them at the end, or even contact us afterwards. We're very happy to have a chat with you. We are covering quite a lot of ground, so this is going to be fairly high-level headlines rather than lots and lots of detail, but we thought it'd be useful to cover some of the sort of more topical areas that you might be thinking about at the moment. So I'm going to hand over now to Kirsty, who's going to look at requests for time off.
Hi everyone, welcome to today's training. I'm Kirsty Hunt, so I'm one of the HR consultants at Quay, as Caitlin explained. So I'm just going to go through different types of requests for time off today and sort of touch on the statutory rights, so what employees' entitlements are, and then talk a bit about some practical guidance in terms of how to manage those requests. If I can go on to the next slide, Harriet, sorry, and on to the next, thank you. So the first topic I'm going to talk about is dealing with annual leave requests, which is covered off by the working time regulations and sets out that employees and workers are entitled to a minimum of 5.6 weeks annual leave per year. So that's equivalent to 28 days, and that would be pro rata for any part-time staff. So best practice, just in terms of letting staff know when your annual leave year runs from, would be to probably set that out within your contract of employment at the outset, or to have it within any holiday policy, just so that they know when they can take their annual leave. So there's no general right under the working time regulations to carry forward to the next leave year any unused holiday, but there is established case law which does suggest that you should do this in certain circumstances. So for example, if somebody is off on long-term sick leave and unable to take their holiday, then you should really think about agreeing to move that on to the next leave year. Similarly, if somebody is off on maternity leave and can't take it for that reason. So that's just something to think about when you're getting those types of requests. There's no legal right to be paid in lieu for untaken statutory holiday, except on termination of employment. And I think a question that we often get asked is, do you have any say over how much leave or when leave can be taken? And the short answer to that is yes, because you as employers, do have some discretion about that and what works for your business. So if people are requesting time off and it is going to interfere with the business operation, then you're within your rights to say, I'm really sorry, but this is just not going to work. But I think the things to think about are just making sure that you're working with your employees to have those conversations, letting them know the reasons if you can't accommodate those requests, and coming up with alternatives that might work for both of you. So another practical tip is just in terms of law firms more specifically, is when you get a number of employees asking for time off for leave, or the same period of time off for leave, that I know can often cause some friction between you and your employees. And for that reason, we would suggest it is best to have some sort of policy in place with a procedure so that not only employees can follow that, but also management can follow that. And that just provides a consistent approach to dealing with those requests. And for that reason, also, if somebody gets refused time off, but another person doesn't, those employees will then understand why that decision was made potentially, and that will save a lot of issues cropping up. So whilst you will always do what's best for your business, if you are getting lots of requests for the same time off for annual leave, then you could think about different ways of dealing with it, such as working on a first come, first served basis, or asking for reasons why they're making the request, so that you can, make a decision about who should have that time off over somebody else. Talking to your employees about any concerns that they might have. They might be able to be flexible with the request, so it's good to have that conversation, or just having a process in place where you may, for example, refer up to management level and somebody else deals with it if it's a case of having lots of requests at the same time. Just moving on to rest breaks. So under the working time regulations, again, all workers are entitled to minimum periods of uninterrupted rest away from their desks or their workstation. This will only apply if they're working a certain number of hours within their working day. As an employer, you should ensure that they can take that rest break, but you don't have to enforce that rest break. So, workers can choose not to take the rest break and continue working, but you just have to be sure that that doesn't raise any health and safety concerns in terms of their colleagues and everything else. And also look at, in the event that you need them to work through their rest break, whether or not you can provide some sort of compensatory rest break instead. So generally, adult workers are entitled to 11 hours of uninterrupted rest per day, 24 hours of uninterrupted rest per week, and a rest break of 20 minutes if they're working a period of 6 hours or more. There isn't any legal right to be paid for the rest period unless you agree otherwise. So you don't have to pay your staff for that, but you may have it within a contract that you do pay them. So it's just best to check that and make sure that you're using, again, a consistent approach for all of your staff, or staff that at least are doing the same type of role. Sick leave. There is no specific statutory right to take time off in the case of sickness or injury, but you may again have this written into a contract of employment for your staff members, and if it's not in there, arguably it should be implied. And the reason for this is because you can't just, for example, dismiss someone for taking sick leave. You would need to deal with that, that situation fairly and make sure that you've gone through a proper process and a proper procedure. So it's just about thinking about doing the right thing. Employees who are unfit for work might be entitled to statutory sick pay after the 3rd day of absence. And in some cases, their contracts, as you know, some of you may do this, you might provide for a higher rate of sick pay in terms of company sick pay. There's no general right to take time off for routine medical or dental appointments if they are unfit for work. So unless the contract specifies that they can, then time off for those types of appointments are completely at your discretion as the employer. Training. So employees working for employers with 250 or more employees are entitled to request time off for training or to study. And only employees with at least 26 weeks continuous service are entitled to make that type of request. The training does have to be for the purposes of improving their work and the performance of your business, but it doesn't have to lead to a formal qualification. If you do receive this type of request, then you will need to hold a meeting with the employee and discuss their application within 28 days of receiving that. And subsequently, you'll have to provide written notice to confirm your decision about whether or not they can have that time off within 14 days. So granting that time off is completely, again, at your discretion, and you don't have to pay your employees for that time off, obviously, unless you want to agree otherwise. So when dealing with these types of requests, it is important that your processes for making those requests are clear and transparent to all staff and to management, just so that everybody understands what the rules are and how to make that request. This does help just ensure that the request is made in the appropriate way. There's not an unreasonable amount of time off being requested, and and ultimately it allows staff to follow something where they will know potentially what the outcome will be. Time off policies should generally include, just as a summary, so how to submit a request, when employees can't request time off or when they can, and how often they can be made, and any considerations that might be specific to your firm. Next slide, please. So I'm just going to move on to talk about family-related time off, which can get quite detailed. So I'm going to try and keep this a little bit short. And as Caitlin said, if you do have any questions at the end, then feel free to ask at that point. So just touching on antenatal appointments, pregnant employees and agency workers do have this right. So they can take time off for these types of appointments, but they do need to be recommended by their GP or their midwife. The only time it might be reasonable for you to refuse this type of request would be if it was made at very short notice and you just couldn't accommodate it. Otherwise, you should be allowing them to have that time off. An employee is entitled to be paid for time off for antenatal care. And similarly, with time off for adoption appointments, again, as long as they can demonstrate that the appointment is there by the adoption agency for either a child being placed or adoption of fostering for an adoption placement, then they should be given the right to that time off. Maternity leave. All pregnant employees, regardless of length of service, are entitled to maternity leave, and this is separated out into two sections really. So you get 26 weeks ordinary maternity leave and 26 weeks additional maternity leave. It's completely up to them how much time they take, whether they take both periods of leave, providing that they give the right notice, and unfortunately you won't have any control over how much time they do want to take. All pregnant employees do have the right to return to the same job on the same terms and conditions, or in some cases a suitable alternative with similar terms and conditions. Whilst they're off on leave, all benefits and terms and conditions should remain the same. The only thing that will be different is pay, because obviously they may be getting maternity pay, which will end after 39 weeks. The employee must notify you in advance of their intention to take maternity leave and their chosen start date for that. The earliest date that they can take that is the 11th week before the expected week of childbirth. But in some cases, the date of maternity leave will just be triggered automatically. So that would be when they were absent for a pregnancy-related reason within the 4 weeks prior, or because the child has been born. So that again would prompt that to play out. As an employer, you won't have much control over when they take maternity leave, but something that you might have some control over is their return date if they don't provide you with the requisite notice. So employees can return earlier than they've agreed with you, providing they provide 8 weeks notice. So if they don't give you that notice, then that's when you might have some control over the situation. So when employees do make these types of requests for time off, whether it be maternity, paternity or adoption leave, it's best that you have some kind of system in place, just again to show them how they make that request. The only difference with these types of requests would be a more formal procedure might not be appropriate, because ultimately it's up to them if they want to take this time. We don't have any say over that as an employer. So it might not be that the way you request annual leave works in the same way as the way they request maternity leave. You might be best placed to just have a designated manager, or for them to inform their line manager of that leave. In terms of adoption leave, so those wanting to adopt would have the same entitlement as what we've just covered off in maternity leave. The only key difference would be the period of leave, and that would begin on the date which the child is placed, or it could be a predetermined date of when the child is going to be placed within the 14 days prior to that. As an employee, they will need to notify you of the date when the child is expected to be placed with them for adoption, and the date on which the leave will begin. And if an employee makes any family-related time off request and you don't have a lot of notice, then sometimes you do have to respond to these types of requests fairly quickly. And it's good to kind of have a plan in place for that, so that if you're left with nobody to do their work, you have contingencies in place. And that might be to have part-time staff that are happy to do overtime when necessary, or it might be consultants that you have on hand that you bring in sometimes, or agency workers. But it's just good to think about what measures you can take if that request comes in, because we don't always know when that's going to come in, and it can obviously have a great impact on the business. In terms of paternity leave, so eligible employees are entitled to either 1 week or 2 consecutive weeks of paternity leave. This should be taken within the period of 56 days, so that's 8 weeks, beginning with the date of childbirth or the date of placement of an adopted child. Again, they would have all the same benefits and everything in place. The only difference would be pay. So the entitlement extends to employees only, not to workers, and it is available to both men and women. It will be up to the employee as to how much paternity leave they take, just providing that they keep within those statutory limits. I just want to touch on a compliance point at this point in the session. I appreciate that sometimes in practice, these types of requests and managing them can be quite overwhelming, and we don't always know what the right answer is. And it's just good to remind ourselves that if we do need some support, under the SRA regulations, there is a competence statement which does say that solicitors should work within the limits of their competence and should know when to seek expert advice. So this will apply as much to running your business as it will to dealing with work for your clients. And if you're unsure about anything, or you feel like you might need some support, then from anything arising from this training or in the future, then we would encourage you to go and get some professional advice or support, because that just helps you make the right decision and avoid any potential risks that might arise from the situation. So paternity leave is unpaid. It's for working parents who need to take care of a child effectively. It can last for up to 18 weeks for each child, and each parent can return to the same job or a suitable alternative job once that expires. There is a degree of flexibility as to the time at which leave can be taken and the way in which the leave can be taken, and it can be split up into a number of shorter periods. This will only apply to employees, not workers, and it is available to birth and adoptive parents, and also anyone who has or expects to have parental responsibility for that child. So this will only apply if someone has been continuously employed for a period of at least 1 year, unless the child is entitled to disability living allowance. If they have or expect to have responsibility for a child, be taking the leave for the purposes of or caring for a child, and be taking the leave before the child's 18th birthday. So where a request is made immediately on the birth of a child or the placement of an adopted child, you as the employer are entitled to postpone the request if it would be disruptive to the business, but you cannot deny the leave altogether or split it up into shorter periods. You would need to consult with your employees about that and reach a decision, which should be done within 7 days of any requests that you receive. Time off for dependents. So employees have the right to take a reasonable amount of time off work to deal with a particular situation that may affect their dependents, and to make any necessary long-term arrangements for that. This only applies to employees, and it will be unpaid leave. So this will cover off things, for example, to provide assistance with a dependent who might fall ill, to make arrangements for the provision or care of a dependent, or if there was a death of a dependent. Employees will need to request this as soon as practicable and give a reason for their request. They should also tell you how long they expect to be away from work, so that you can obviously manage the workload and what's happening there. In theory, you can prevent the employee taking more time off than is reasonable, but the disruption or inconvenience caused to the business shouldn't be taken into account with these types of requests. So just before we conclude this topic, I just want to run through some general considerations with you, which we've briefly touched on already. So Policies that involve these types of requests should be made very detailed, very clear and concise, and they should be applied consistently to all of your staff and available and easily accessible by all your staff and management, just so that everybody's on the same page, everybody's working to the same procedure. It just helps these requests get dealt with much more easily in practice and avoids any issues arising between staff. If you can show some flexibility when dealing with them, then I would do that. That might involve, employees trading annual leave days or being more flexible, or, you coming to some sort of other agreement. I will talk through policies in a bit more detail later on, but you should be looking to share your policies on these types of things and all policies with your staff as soon as they start employment with you. And if you haven't done that, or if you are updating policies, then as soon as those updates have been agreed and are available. We've just at this point included a poll for you just to ask a question, and we would really appreciate your response on this. Do you think your policies for employees requesting time off are clear, or could they be improved? So if everybody's completed the poll, thank you very much. I'm going to hand over to Caitlin now, who's going to talk about menopause in the workplace.
Thanks very much, Kirsty. So I'm just going to look for the next 10 minutes or so on managing the menopause in the workplace and some of the issues that you might want to think about. So Harriet, if you could just take me on to the next slide, please. So the first thing, just before we get started, is let's have a think amongst the delegates of how many of you have a menopause policy in place at your firm. Can you just answer yes or no on that poll question, please? Once we've got everybody's answers in. Wow, 100% no. So that's really interesting. That's one of the things that we will be thinking about. I would say that probably reflects the experience of working with our clients. It's still quite a new thing to have amongst your policies, although we are starting to get many more requests for that sort of thing. Can I go on to the next slide, please? Okay, so let's think about why is it important? Why are we talking about how you would manage the menopause within your firms and within your workplaces? It's an issue that probably hasn't been discussed very widely until quite recently. But if we think about some facts, so there are just over 15 million women in the UK workforce currently, with 3.5 million over the age of 50. In the UK, the average age that women go through the menopause is 51. However, 1 in 100 women experience the menopause before the age of 40. So the takeaway message is this is a normal process for a large proportion of your workforce. Around 1 in 8 of the British workforce are women over 50. And by 2022, it's forecast that that's going to be 1 in 6 women. 1 in 6, will be women over 50. Most women over 50 will have or have had menopausal symptoms their work, and for 1 in 3 the symptoms will be severe. So some ACAS guidance on the menopause in the workplace states that over 2 million women aged over 50 have had difficulties at work due to menopausal symptoms. That might be a loss of confidence, feelings of stress and anxiety surrounding the ability to do their jobs. So it's really critical for all employers to be giving this some attention. And let's just think for a moment about what the symptoms are of the menopause, because for many people, including myself, when I started researching this topic, it's much more wide-ranging than you might imagine. For many women, symptoms last a number of years, and on average about 4 years, but can last much longer than that. And the symptoms can include the sorts of things that most of us will be quite familiar with, so the ideas of sort of hot flushes, but can also include all sorts of other symptoms: feeling tired and lacking energy, feeling anxious and having panic attacks, struggling to concentrate or losing focus, headaches including migraines, low mood and depression, and problems with memory and concentration. So the symptoms, of course, will vary from person to person and will range from very mild to severe. If people don't get help when they're suffering from those symptoms, it's increasingly likely that that's going to affect their ability to carry out their work in the way that you would want them to and that they would want to, could lead them to be feeling really very ill, losing confidence to do their job, suffering from mental health conditions such as stress, anxiety and depression, and ultimately for some people leaving their job. So there's a real impact on work that makes it relevant for you to think about. Can we go on to the next slide, please? So let's think about some positive things in terms of what you can do in this situation. So currently many employees simply don't talk about their menopausal symptoms within the workplace. And if they take time off because of those symptoms, they often don't reveal that that's the real reason for taking that time off. And that might be because they feel that those symptoms won't be taken seriously, that if they talk to somebody, that it will become common knowledge within the workplace that they're suffering or that they're going through the menopause, that they will perhaps be thought to be less capable, or that it will affect them negatively in the workplace. So perhaps it would affect their the duties they get given or their opportunities for promotion and so on. So ACAS have come up with some tips to help employers in this situation. And the first thing on there is to create and to implement a menopause policy. So that's certainly something to think about. Also to provide awareness training for managers to deal with any concerns in a sensitive way. And I think that's absolutely key. To create an open and trusted culture within the workplace so that people can come forward and talk to their managers knowing that they can be open and that they're not going to be judged and they're not going to have any negative consequences as a result of doing that. And then think about some practical changes that could be made to the workplace to help individual women going through certain symptoms, and I'll talk about that in a moment. And be aware of employment laws that impact on this area. And again, I will talk about that in a moment, but there are risks around sex, race or age discrimination here. So what sort of adjustments might we think about making? Well, there are some physical adjustments that might help with certain symptoms and might be useful. So what's the temperature like in the office? Is there enough ventilation? Is there somewhere suitable for that employee to rest? Whether the toilet and washroom facilities are suitable and easily available. Is there cold drinking water available? But there are also some wider adjustments perhaps to your culture that you could think about. So is it a culture in which open discussions can take place without fear of judgment? At the same time, if employees raise things with a line manager or with you and ask for them to be kept private, then you will of course need to respect that. Could adjustments be made to working patterns or working locations, such as home working? Might that help in certain situations? As I said, training all managers, team leaders, supervisors to make sure that they understand the impact that the menopause can have on women who are in the workplace is really critical. If I could go on to the next slide, please. So just to touch really briefly on some of the legal risks around this. So as an employer, you have a duty to protect the health and well-being of your staff and not to undermine the implied duty of trust and confidence. And there are two key strands of employment law that are relevant here. So the first is the Equality Act, which protects employees against discrimination. And as I've said, you could see that there could be arguments around sex, around disability and around age discrimination in this instance. The Health and Safety at Work Act is also relevant because that states that an employer must, where reasonably practical, ensure the health, safety and welfare of their employees at work. So there are a number of different possible challenges that could be brought by employees who are going through these symptoms if they're not handled in the correct way. In relation, and the sorts of claims we're starting to see coming through the employment tribunals, and there is an increase in claims where the menopause is referenced, would be around disability discrimination and a failure to make reasonable adjustments. It is important to note that the menopause in and of itself is not deemed to be a disability, but symptoms may be, depending on how long they've been affecting the woman and how the symptoms impact on her ability to carry out day-to-day activities. So what can you think about doing today? So some of the things that I've talked about, looking at a menopause policy, training on health and well-being, expressly mentioning menopause in any diversity and equality training that you might be doing with your staff, signposting employees to workplace networks and online support groups can be really helpful. Making sure that you're accommodating menopause fairly when you're dealing with sickness, so perhaps you would reference it in your sickness policy, and creating that environment where employees can talk openly is really useful. There is some guidance available from the Law Society on the menopause. It is quite recent guidance, and that can help both individuals and firms to access the support that's available. So it's got really helpful recommendations. It offers support to individuals, and it gives a useful overview of the menopause and explains why employers need to start focusing on that and providing support to employees. And there are also a variety of links within that to various resources, so it's definitely worth having a look at that. And I'll hand back over to Kirsty for the next topic.
Thanks, Caitlin. Sorry, I'm just checking that I'm visible. Yeah. Okay, so I'm just now going to talk a bit about contracts and policy reviews. So we all know that contracts form the basis of our working relationships, and they set out our expressly agreed terms and conditions of employment. In line with our contracts, we then have policies and procedures in place to not only ensure compliance with legal obligations, but also to help set out the firm's expectations and help keep everyone accountable. And they just, again, provide that support for staff and some guidance for them. The implementation of good policies and procedures and their regular review will help in terms of reducing the risk of any legal claims, compliance issues, or even internal grievances. So although contracts and policies don't generally have a sell-by date, they do age over time. They do become outdated. Things change and evolve all the time. So whether that be compliance obligations or new legislation coming into force, it is crucial to plan for this and obviously undertake regular reviews of these documents. Policies and procedures can sometimes be viewed as inflexible and as though they can't be changed, but that isn't the case. They should really be seen as living documents that are regularly updated to ensure compliance and reflect new technologies and any detection of new threats and just general growth that's happening within your law firm. Sorry, next slide. Just gone through that. So if we can just do a quick poll. So when did you do your most recent review of your contracts, policies and procedures? If you can just answer which one is most suitable to you. Fabulous. So 50% of you are saying within the last 3 years. So that's quite a long period of time that you're not reviewing your policies, not ensuring they're compliant with, recent legislation. So obviously some of you will be doing it a bit more frequently, but I think, that's just a good indication of the fact that we need to be thinking about doing this much more regularly. Thank you for doing that one. Next slide, please. So when should we do it and why should we do it? So maintaining legal compliance, which we've just touched on. So laws change, they change often. It's more likely that they may have changed since your contracts were originally signed or your policies were last updated. So for that reason, carrying out regular reviews does help just to ensure that all of the terms and the information within your documents are still legally enforceable. And if you do fail to comply with any legislation, then you do risk damage to your reputation, a fine, or even worse. So it's definitely worth thinking about having a review of those. Law firms are highly regulated, and a number of factors to think about, such as data protection and obligations under the SRA, are also considerations when thinking about updating your contracts and policies. Adapting to changing business needs is another one. So if the past 18 months has shown us anything, it's that it's not just the law that changes, it's everything else. Reviewing documents does allow you just to ensure that they're up to date, they're consistent with your firm's approach, And I know that everybody will be working in a slightly different way now to what they did pre-pandemic. So it might be that you need to do some updates in terms of how you're working now. So another one just to touch on is document modernisation. So contracts and policies are often long, and they sometimes, I appreciate, do feel quite unmanageable. So I think it's more essential for that reason to undertake regular reviews and effectively look at streamlining your documents, just making sure that they're really clear, they're comprehensible, and that they're accessible and up to date. Understanding individual responsibilities. So workforces are forever changing. Teams may have changed considerably since the contracts were first signed, and it won't always be the case that you need to update them. But for those responsible, you should just be aware and understand the risks and legal rights and obligations that come with this. Reducing risk, as I've already touched on. So law is a highly regulated industry. Frequent and comprehensive review is a necessity just to help reduce the risk of any legal claims or compliance breaches, or ultimately loss of reputation. You need to make sure that things are in place and that you're doing what you should be doing. So when is it best to review them? So we've already found out that you guys, as a general poll, are not reviewing them within the 3-year period. We find that it's best to do it regularly and proactively. So not just in relation to an event or something that's come in as a change. So rather than wait for a problem or violation to decide to take that review, just do it on an ongoing basis. Have a regular process in place to do that. And the best way of doing that is to put it into your calendar on an annual basis and make sure that at least once every year you are looking at your contracts and policies, just to make sure that there's nothing that should be updating on those. Next slide, please. So I'm just going to talk through some events that often trigger those changes to be made as well. So organisational change. When your firm undergoes large scale changes, such as in strategic direction or having new leadership, or even if you undertake a merge with a different firm, it's essential at all of those points as well, just to remember to review your policies and contracts and make sure that they align with your values and your visions and how you're working at that time. Changes to laws or regulations. So changing laws and governmental regulations will affect certain procedures. In terms of compliance, you will need to be aware of these changes and know which policies that they do affect. If there is a big regulatory change on the horizon, then we would urge you to sit down and go over this and review it, become aware of it. Don't wait for it to come in, be prepared. It's all about preparation and knowing that you're going to be ready for that change. Essentially, if you build in regulations into your policies early on, then the transition will be much smoother once it comes into effect for everybody. And incident or policy violations. So this is another one. So this does indicate a need for change. Any kind of incident, it's a good idea to debrief and make sure that your policies have the intended effect, even if the violation still occurred. So examine the details of the incident to see if all procedures were properly followed and whether there were any gaps in any training or anything like that, so that you can make small changes and do your updates. Not every violation should result in sweeping changes, but if you find repeated violations, especially in the same area or of the same type, then the issue may be that the policy is just too outdated or too confusing. And the other thing to think about is whether your staff need training on particular policies, just so that they fully understand them and they know how to use them. Next slide, please. So identifying and updating. So how do we identify if a document requires revision? So it doesn't always have to result in a document revision. Sometimes major changes and revisions do need to take place. Other times we don't need to do anything at all. So it's just about knowing which ones you need to update. And here are a few questions just to consider. So is the document being implemented as intended? Sometimes it is quite apparent if a policy or contract is not being complied with. And the important question to ask is, why isn't it being complied with? Perhaps the document is outdated or the language is too complicated to understand. There might be reference to a new technology which is not understood, or perhaps the document is missing new technology which invalidates its usefulness. So it is important just to obtain feedback from those using the document on how you can improve on it and make sure that it is effective. Is the document having the desired effect? So every policy and contract should have a clear goal or objective. This should help you measure whether the document is effective over time, and you should ask for feedback on the effectiveness of the policy. So ask yourself, where has positive change occurred? Has there been any confusion, and how could things be improved? Are the contracts, policies and procedures current and relevant? That's another question to ask. So reading through the document will help you to identify areas where it's clear there is a disconnect in how your current systems and structures operate, and this can result in non-compliance by you and by those following the document. So, again, it just emphasises the importance of having these regular reviews. How to update relevant documents. So once you've identified the documents which you need updating, you will need to put that into action. So we'll just touch on what the best approach for that might be. So determine who is involved with the document in the first instance. So you should select appropriate members of your team to review the documents based on the work that they do and the document that you're reviewing. It might be sensible to include different people at different levels to do that as well, just so you're getting input from those that are affected by the document as well. Determine whether you need to make any comments or changes. So it's very important that as the team conducts that review, or whoever is reviewing your policies or contracts, that they should make sure they write down all comments, notes, and get input from other people that are necessary. This kind of information is quite important because if there are any issues that arise at a later point, this just helps demonstrate how the decisions were made to change the document and your decision-making process. It's probably best to test the finalised document on individuals outside of that team of individuals that have reviewed it, just to go through the process and get any feedback after you've done that. I appreciate that might sound like quite a long process, but if you're going to do it internally, then it's probably best to kind of have those measures in place just to make sure that it is being done properly, and you are, having effective changes made at the end of it. If you do need any help with amending documents or reviewing policies or anything like that, obviously you can come to Quay HR for that support. We do provide support for that kind of thing. We do have things in place so that we can review your current policies, tell you what we think is missing, and provide you with new policies, or just amend what you've got already in terms of what suits the business, really. So do come and have a chat with us if you need any help with that. I'm just going to hand back over to Caitlin now in terms of appraisal and performance management.
Thanks, Kirsty. Could I go on to the next slide, please, Harriet? Right, so before I start talking, let's do another poll. So how beneficial do you find employee performance reviews and appraisals for you as a business? Okay, so that's good. A very small number saying either a waste of time or we don't do them. Most people beneficial, and some people very beneficial. So that's positive. Let's go on to the next slide, please. So I want to think really about practical considerations rather than taking you through, exactly the nuts and bolts of what performance management might look like. So why and when and why do you manage your team's performance? So when, well, really the answer to that is you should be managing their performance all the time. So it's an ongoing process. It's not just about an appraisal meeting once a year and then nothing in between. And I'm sure that's not how you would manage performance. So it's an ongoing process. And why do we do it? Well, that's a longer answer. So there's all sorts of reasons that you should be managing performance within your organisation. I think one of the key things to think about here is that managing performance is about both positive and negative performance. So it's good and bad, and it should be seen as a positive and a supportive process. Very often when you mention performance management or appraisals to employees, there can be a bit of a groan because it's seen as something that's quite negative, but in fact it should be seen as a supportive and positive process. So good performance management arrangements can help an organisation to motivate staff, to check that staff are making valuable contributions towards the goals of your organisation, to develop those staff, to recognise and acknowledge the good work of your employees. I think that's absolutely critical during the last 18 months or so, when people have been working under some really challenging circumstances, to deliver on their work, so their tasks and their projects quickly and to the required standards, but also to spot and to improve poor performance where that does come up. Good performance management should increase engagement from your high-performing staff and should open up conversations about people's personal aspirations and professional developments as you have those conversations with people. There will be, of course, instances where you come up against some underperformance, and then you have to think about how you are going to manage that. And why would we do that? Well, because you will want to improve the quality of the work that's being carried out by your firm. You want to encourage the best employee performance that you can. You want to avoid other members of the team perhaps carrying somebody who's not performing so well, which then will have a knock-on effect in terms of team morale and motivation and so on. And generally, it will improve the overall performance of the business. It's important to try to spot potential issues early and to tackle them at that early stage rather than letting them become more serious. And we need to focus on thinking about staff morale and improving that staff morale, which can be difficult if there is low performance in certain areas of the business, perhaps. Thinking about performance management, it should be a conversation, a two-way conversation between managers and between employees. It shouldn't be a one-way conversation. So developing performance, well, individuals will of course bring different skills and different experiences to the role when they're recruited. And so regular development is really important in terms of harnessing their skills, but also focusing them on what's needed for that particular role. And even once fully trained in that role, further development is really important. So offering staff suitable development opportunities can help to keep them motivated, can build loyalty towards the organisation, can fill any skill gaps that you might have perhaps, and can provide them with opportunities to progress their career. I just want to talk briefly about probationary periods because they often get overlooked, we find. So all new starters should have a probationary period set out in their contract of employment. And the purpose of that probationary period, of course, is to assess an individual's suitability for the role that they've been recruited into. And it would generally provide a shorter notice period during that probationary period. And it's really important to use those probationary periods effectively. They are absolutely there for the purpose of assessing whether or not that individual is going to be suitable for the role or not. So monitoring their performance during that period of time and assessing whether or not there are any concerns or not is really critical. Now, you might, of course, identify that there are some areas of concern, but perhaps some more support could be put in place or some training might be required, and that might deal with those concerns. But be clear when there is a new starter what the probationary period is and diarise that probationary period, because all too often you will find employers where there is a probationary period in place, it hasn't been diarised, time has ticked on, and before you know it, that probationary period has passed and it hasn't been acknowledged at all. And perhaps there were some concerns for that individual, but they weren't addressed because everybody sort of forgot that that probationary period was there. So don't let that happen. Do utilise it, diarise it, and make sure that that person is right in that role. It is possible to extend a probationary period. So if you have got some concerns about an individual and you think it would be useful to have a slightly longer probationary period, then that's quite a sensible thing to do. You just need to communicate that effectively with the employee so everybody's clear about what's happening. And then what does the process look like in practice when we're talking about performance management? What sorts of things are we talking about? Well, we could be thinking about regular one-to-ones with people that you or team leaders or managers will supervise. Could cover support with staff who are perhaps struggling or who need some additional training. It could cover things like training and development for your staff members. And it's also going to cover the more formal appraisal process. So let's look at that in a bit more detail. Harriet, could you take me on to the next slide, please? So let's think about appraisal. So appraisal or a PDR, performance development, it is a way of regularly recording an assessment of employees' performance, of their potential and of their development needs. So it's an opportunity to take an overall view of how they're doing, look at their workload, look at what they've achieved over the past year, and then think about objectives for the year ahead. It's also an opportunity to talk to them about their aspirations, about their concerns if they've got any. They may well have observations about the way that work has been done or could be done. So it can be a really useful two-way conversation and should be seen as that, and ideally should be employee-led. So it's really important to encourage employees to prepare for their own appraisals so that they are going into that meeting ready to talk about their experiences over the past year and what they might want to aspire to going forward, rather than just sitting and being on the receiving end of information from their manager. I think there's also been a real move away from the idea of appraisal being a one-off annual meeting where everybody sits down, goes through some forms, they get put in a drawer and nothing happens for a whole year, which I think we all know probably from our own experience, it is just not particularly helpful. Things change throughout that year quite fast sometimes, and so it's helpful to think of that appraisal process as an ongoing process, to have regular check-ins, even if that is a half-hour check-in once a quarter perhaps, to just see how things are going. Are those objectives still relevant for that individual? Do they need any kind of amendment? So seeing it as a much more ongoing process is useful really, rather than just a one-off meeting. So what are the benefits of having appraisals? So for an individual, it's a chance to understand their role and achieve clarity in terms of what's expected of them, to gain feedback on their performance over the period of the appraisal and recognition for good performance, to identify strengths and plan development within the organisation, but also to receive support if there are any difficulties, and to identify any areas of underperformance and try to work out why they have arisen. It's critical, I think, to point out that at the appraisal, particularly if it is really an annual appraisal and not much happens in between, not to store up problems, to then put them all to that employee at that annual appraisal meeting where they have no knowledge of those issues in the run up to that. Really, if there are problems around underperformance, they should know about those already, and you shouldn't be storing things up to just put them to them at that appraisal meeting. It should be seen as an opportunity for feedback on both sides. It may be, for example, you have got a member of staff who is clearly struggling and so underperforming perhaps, but perhaps they're underperforming because there are some issues within their team, because there's more work than you thought there was, or there are some difficulties with the tech or the IT or whatever it might be. And that's an opportunity to hear about that from the employee. Perhaps there's a health problem that you don't know about. And again, it's an opportunity to have that conversation and hopefully understand it in a bit more detail. I'll just touch on setting objectives, because very often when we work with clients around introducing or improving appraisal systems, setting objectives is one of the areas that causes some concern and can be quite tricky, I think, for people to get their heads around. it's obviously important that if you do want to set objectives for your employees, that they are clear and measurable and understandable. Otherwise, there's very little point in doing them. And really is a great opportunity to be setting objectives which tie in the work that those individuals are doing with the strategic plans for the organisation, so people feel that the work that they're doing can really influence the wider plans of the firm. So it's a great thing to do, but it can be tricky for people to get their heads around. But I think it is worth training your managers on how they do that, so that they feel confident about that objective setting when they're working through the appraisals with their teams. So some challenges around appraisals and around performance management generally. One of the things I think that we find is a real challenge is very often managing performance, and particularly poor performance, requires people to have difficult conversations with their staff. And people find that understandably sometimes quite difficult, and as a result sometimes avoid having those conversations. And that in turn makes the situation worse because it hasn't been tackled, and it gets even worse than it was. So the message would be, have those difficult conversations early on while you have identified an issue, but it hasn't grown into something huge. If you know that you have got people who are managing performance but possibly are struggling with those difficult conversations, then think about providing some training for them so that they may feel a bit more comfortable about having those conversations, because it's really important to be able to raise those issues with people and to use really clear language that people understand. I think there can often, particularly perhaps in smaller settings, there can be a temptation to use quite soft language with people because you work alongside them and you're friendly with them and you don't want to use language that might upset them, but they may come away from that conversation not actually understanding the point that you thought you were going in to make. So using really clear language, preparing a script in advance or just some bullet points so that you know you're keeping on track can be really helpful. My second challenge that is around keeping a PDR process on track, so particularly with appraisals, one of the reasons that they don't always work particularly well as processes is that they're time consuming and people don't have enough time, and therefore they get done as a bit of a tick box exercise and everybody breathes a sigh of relief and they're done for another year, or they don't get done because people simply don't have time. So make sure that they're spread out evenly, make sure that the process is as streamlined and user-friendly as it can be to try to tackle that. I would just thought I should mention in passing really the implications in terms of performance management and unfair dismissal. Poor performance can, of course, ultimately lead to dismissal. Those dismissal on these grounds, on this ground, is extremely rare. So employees have protection from unfair dismissal if they have 2 years service, but there are ways in which they can bring other claims when they have much less service than that, particularly around things like discrimination and whistleblowing. So you've always got to be very cautious. It is possible to go for a dismissal on the grounds of capability. You also have to have a fair procedure alongside that fair reason for that dismissal. It is quite unusual and it's a very lengthy process to take somebody through, but to actually get to a dismissal on those grounds, and generally speaking the person will leave and seek another job, or perhaps a settlement will be reached. It can be also just quite difficult to distinguish between poor performance and misconduct, and so working out the lines between those two can sometimes be quite tricky. So it's worth taking some advice around that if it comes up. I'm going to pass back to Kirsty. Thank you.
Thanks, Caitlin. So just to kind of finish with the end topic of this training, I'm going to have a look at post-COVID working. I think, we're all aware that lots of changes have happened over the last 18 months. There is a new way of working for everybody, including this hybrid working, so working from home and the office. And since the removal of the restrictions, I think it's just good to go through what things we need to think about really. So next slide, please. So the legal position. So can you make an employee come back to the office? So if an employee's contract of employment states that their workplace is in the office, then you are within your rights to ask them to come back into the office and work from there. But there is a caveat to that. So given everything that's happened, it's important to note any knock-on effects in terms of forcing employees to come back into the office, especially full-time. Downing Street have confirmed that there is government are considering legislation to make working from home the default position, so that employees have the right to request it. And they're basically implementing a flexible working task force to examine how best they can proceed with that. So home working, has become the norm for recent times, and we need to kind of consider for each individual employee and the business how we're working going forward and what works best for both of us. So ideally, you should be looking to discuss your approach with your staff, look at phased returns to the office rather than coming back immediately full time, and just respecting the environment that you work in until everybody gets used to the new way of working. Next slide, please. So COVID safe office, so just touching on this. So a recent survey has shown that 68% of employees are worried about contracting COVID when they return to work. For this reason, it is probably sensible to let staff know that you're keeping on top of health and safety precautions and you've got measures in place to protect them, such as wearing masks, social distancing with screens, and keeping office windows open, keeping ventilation. It's quite equally important to listen to your employees about their own concerns and allow them to work remotely if you can, just until they feel comfortable in returning to work and that they feel safe to do that, especially for those that are that more vulnerable. Whilst there is government guidelines to say that as a minimum they should follow the same guidance as everybody else, they do obviously need to think about in terms of their own health, anything that they should be putting in place as an extra precaution, and that could include being around people when they don't have to, so coming into the workplace. So it's just something to think about and have a chat about with your staff members. So just touching a bit more on having a dialogue with your staff around what works best for them. It won't always be a one-size-fits-all approach. You can help reduce the number of staff in the office at any one time, and manage any outbreaks. So you should consider implementing any frameworks for keeping in touch with staff who are working from home. And this might include different forms of communication. So from formal group and individual meetings to unplanned drop-ins, as well as non-work related catch-ups and social events, really. Whatever approach works for you, you should go with that. But you do need to make sure that there is some form of effective communication in place with all your staff members, regardless of how they're working. So one of the questions that we do get asked all the time is, how can I make employees get the vaccine? The bottom line is you can't, unfortunately. You can't force anyone to be vaccinated. You can strongly recommend that staff do have the vaccination, but you do need to be aware that some of your employees may not want to get this for health reasons or religious reasons, or because they're pregnant, for example. So you shouldn't really be making any assumptions about their resistance to the vaccine. But again, sometimes it is worth just sitting down with your staff members and having that chat. Whilst you might want to encourage them to be vaccinated, you will need to tread carefully and just think about their well-being and any impact that might have on them if you are being quite forceful about that. Under current health and safety legislation, employers do have a duty to protect the health of their employees and anyone on their premises and anyone else affected by the business. So vaccination guidelines do state that if a risk assessment finds a risk to exposure to biological agents or effective vaccines exist, then employers should offer to provide immunisations to those who aren't already immunised. No jab, no job. So whilst the government is introducing a mandatory vaccination requirement, which will apply to all care homes in England, and it will extend to non-exempt persons who enter a care home building regardless of their role, we don't have any case law yet to assist us with determining whether or not failure to have the vaccine could potentially be a reason for dismissal. So it might be viewed by the courts that terminating because someone isn't vaccinated could amount to discrimination and potentially unfair dismissal. So you just need to keep that in mind when you're thinking about that. Next slide, please. So if we now come onto the poll, will all your staff go back into the office? It would be really interesting to know if you are getting your staff back in or if they're staying at home. So 62% are saying that yes, staff will be going back into the office, and 38% are saying no. Thank you for doing that. That's quite interesting. I think that's probably to be expected. Majority are going back into the office, but there are still a lot of people that are really worried about doing that. Next slide, please. So the future of working from home. So I'm just going to talk a bit about hybrid models, flexible working, and discrimination risks. So some employers have shifted to a remote or hybrid model for the long term. Though employees have no automatic right to work from home, they do have rights when it comes to flexible working. So if they've got 26 weeks service, they can make a flexible working request. And as an employer, you will need to consider that in a reasonable manner. You can refuse the request, obviously, if you've got good business reasons for doing so. Some of these reasons could be the burden of additional costs, the detrimental effect on the ability to meet customer demand, an ability to reorganise work among other employees, inability to recruit additional employees, a detrimental effect on quality or on performance, or insufficient work at the times when the employee proposes to work. This might also be due to planned structural changes. So discrimination risk, I would just flag with you to be aware of the risk of discrimination when dealing with these types of things. So more women than men do seek flexible working arrangements, and a rejection of a woman's home working request could amount to indirect sex discrimination unless that treatment can be objectively justified. So a disabled employee may also have some protection in relation to home working, particularly if there is a duty there for you to make reasonable adjustments. So that's just something to be mindful of when you are taking decisions or dealing with requests from your employees. So that concludes all of the topics. I think we're going to move on to some questions now, if anybody has any.
Thank you to both Kirsty and Caitlin. And certainly that last topic is one that anecdotally people have been telling me out on my visits recently that they're struggling with. So I'll come back to that in a second. But we do have 10 to 15 minutes available now for questions. As I mentioned earlier, you've got a couple of options there. We have got the chat function, which is on the toolbar at the bottom of the Zoom screen. So you are able to pop a question in there, either direct to me or one of the other speakers, and we can read that question out for you. Or if you're happy to unmute yourself and ask that question yourself, then you are welcome to. I've been getting back out and about seeing people in the last couple of weeks, and people are telling me that particularly in some of the smaller firms, it has been quite a challenge to have people working from home. They weren't necessarily geared up for that to happen at the start of the pandemic. We've obviously all got more used to it, but particularly in smaller firms, suggestion seems to be that really they would prefer to have staff in the office, and that is potentially causing problems with some of the firms that we deal with, where staff are seemingly reluctant to go back into the office. So I think very timely kind of reminder there of the factors that need to be taken into consideration. So we don't seem to have any questions coming through. So I'm going to remind everyone that the slides and the recording will be sent out in the next day or two, so that you'll have access to the materials that Kirsty and Caitlin have provided today. We'll also be inviting you to join the Narrow Quay HR club that they run, and which, as far as I understand, it includes kind of occasional training updates and newsletters. And we offer the Narrow Quay HR consultancy service as a benefit to VWV Approach members, where the NQHR team offer a discount on the initial joining fee. So VWV Approach members benefit from a 20% discount on that initial fee, which is a bit of a fact-finding mission, seeing what you've already got in place and looking at what support can be offered. We also offer a retainer service, which is low-cost service, having the consultants available to answer your kind of day-to-day HR queries, and that structure being set in place so that you know you can be making use of it. They can also support on a project basis. So if there was something particular that needed to be done, we've had one just last week actually. Another law firm has referred a client to us where an investigation needs to take place because a grievance has been raised in a very small practice, and so the NQHR team are looking at what we can do to support that and provide a sense of independence in that process. So lots of ways that the narrow Quay HR team can help both you as lawyers running your own firms, but also the clients that you might be working with. Do get in touch with the VWV Approach team or direct with Caitlin and Kirsty if you've got any queries from the back of the event today. I've mentioned there are a few prospects here not already members of VWV Approach, so I'll be in touch with you to follow up about that. And just a reminder that our next event is looking likely to be the 7th of October. We're just finalising the content on that one, so details will be coming out soon. But otherwise, I think in the absence of any obvious questions coming through, that just leaves me to say thank you for taking the time to attend this afternoon, and please feel free to get in touch if there's anything we can do to help.